We've made it through a basic definition of real estate. We've made it through how to describe real estate. We've talked about how to encumber real estate with things like liens. Now we want to actually transfer that title. We want to move that ownership from one person to another person. Okay? So you could put one word on the name of this chapter. Deed. That's what this whole chapter is about. A deed. Because that's what a deed does. A deed is a method, it's a document that transfers ownership, and we call ownership title. We call it title. Transfers title from one person to another. If you ever see a test question where you're asked what's the primary purpose of a deed, well, the primary purpose is not to prove ownership. The primary purpose is to transfer ownership. That's what the document does. It's a document, it's almost like a bill of sale is a bad way to put it because that's what we use for personal property, but it's like that version of a bill of sale. It basically says, I'm the grantor, I own this property, and I am transferring it over to you, the grantee. That's what a deed does. It moves title. We use words like deed and title because almost all of our law comes from English common law. And if you were a citizen of the Crown in the United Kingdom or Great Britain in the 1300s or 1400s, the only way you could own property is if you were nobility. You had a title. You had to have a title in order to own property. And if you if you weren't born nobility, the only way you could gain title was to perform a good deed such that you were granted a title by the Crown. That's where that terminology that we still use comes from, the words title and deed. Not that you know that for the test, but sometimes I think it just kind of helps cement it, that there's a reason those words are used. Okay? All right? So, title is the evidence of ownership. Here's the thing though, it's not a piece of paper, it's an idea. Title is an idea. We don't have a piece of paper that proves our ownership. What we have is a piece of paper that proves ownership was transferred to us. That's the deed, right? That just proves ownership was transferred to us. There is no piece of paper that proves you own it right now. There's no such thing. All you can do is prove it was transferred to me at this point in time. Here's the deed. And nobody else has shown up with a different one saying it was transferred to them since then. Does that make sense? There's no piece of paper, no document you can show that proves you own a piece of property right now. Okay? Two ways we can transfer title. We can do it against your wishes or with your wishes. Voluntary or involuntary. What do you think another word for involuntary is most commonly? Foreclosure. Now, foreclosure is definitely not the only way we can transfer title involuntarily, but it is the most common way. What's the most common way for a voluntary alienation?
A sale.
A sale. Absolutely. And that word alienation just means transferring title. That's all it means. When you alienate yourself from the property, you've transferred it from yourself to somebody else.
What's another involuntary?
Another involuntary, we're going to talk about them. There's several of them. Adverse possession is involuntary. Condemnation is involuntary. But we're going to talk about a bunch of them. So, things that you need for a deed to be valid. And this word valid, I want to point out, has a specific meaning. Valid means it would be enforced in a court of law. Okay, that's what valid means. So don't worry about that definition right now. Don't write it down necessarily, because when we get to contracts, that's a big focus. But I just want to point out to you that valid does have a legal meaning. When we say a document is valid, that means a court of law would enforce it. Okay? So these are the things that are required for a deed to be valid. It must be in writing. Now, I'm gonna point out something to you that doesn't come up till a little bit later in the book, but I like to do it right now because it's the first time we've told you something absolutely must be in writing.
What page is this on?
79.
Thank you. This is not yet in this chapter, but it's coming up soon enough anyway. And since this is the first time we've told you something had to be in writing, I want to point out a law to you. It's called the statute. Statute is just another word for law, right? Of frauds. Not frogs like the hopping kind. Frauds like the con man kind. The statute of frauds. Write that down in your notes. You will see that on a test. The statute of frauds has to do with one thing. Things that must be in writing. It's basically a list of documents that the state of North Carolina says we will only honor these types of documents if they're in writing. So when we say something is covered under the statute of frauds, what we're meaning is that for that thing to be legal in a court of law, it's got to be what? In writing. So if something's not covered under the statute of frauds, that means you could maybe have an oral version of it, right? For an example, in North Carolina, leases are not covered under the statute of frauds. So what does that mean you can have? What kind of lease? An oral lease. And it could be enforced in a court of law. You could go to court, you could testify, no, we agree, this is what I would pay, I paid him, we've got a lease. And the court would honor that lease, even though you didn't have anything in writing. And the reason is state law doesn't say that leases have to be in writing. But it does say that deeds have to be in writing. Deeds are covered under the statute of frauds. Does that make sense for everybody? So just think of it as it's a law that says if this document's on this list, then it must be in writing for us to enforce it in court. And there's a big long list of the documents that are covered. That's what the statute of frauds is. Okay? So deeds must be in writing. We say we must have a legal capacity of the grantor. That's on page 79 and 80. It says the grantor must have a legal existence, be of a lawful age, that age happens to be 18, and competent, legally competent. So that means you can be crazy as long as you don't have papers that say you're crazy, right? If you have papers that say you're crazy, then you're not legally competent. There are plenty of crazy people who don't come with papers that can sign a deed. Trust me, I've met them. Notice it says the grantor must have all these things. Does it say anything about the grantee must be of a legal age and have a legal capacity and all that stuff? No. Who's the grantor? Who's the grantee? If we're talking buyer and seller, who is who? Seller is the grantor. Buyer is the grantee. So, dig a level deeper. Can the seller be a minor? No. Can the buyer be a minor?
Yes.
Yes. See, that's that level deeper. You have to think about these things. It says the grantee has to be all these things. It doesn't say anything about the grantor. I guess the grantor can be crazy as hell. I don't know. I mean, the grantee can be crazy as hell. And I don't know. Yes. Whatever. But the grantor has to be all those things. Okay? So the grantor must have legal capacity. Be old enough, be not crazy. It says the grantor and grantee must be identified. We need some words of conveyance. Don't worry about that. What else do we have to have? What we just talked about in chapter 4. A legal description of the property. What in North Carolina, what kind of description would that be? Meets and bounds. In states other than the original 13 colonies, what description would that be? The government rectangular survey. Exactly. Okay? And it must be signed by which party? The grantor. Does the grantee have to sign the thing? No. If you're buying a property, you don't sign the deed. Because here's the thing. What are you signing for? What is the purpose of the deed? To do what? Who's transferring? The grantor, the seller, right? It's the seller, the grantor, who's doing the transfer, so they're the ones signing. Okay? And must be delivered and voluntarily accepted. I guess you can't force somebody to take a property. Okay? Things that don't have to happen for it to be valid. Now this is where it gets confusing. Remember I said valid meant it could be enforced in a court of law. The things that we don't have to have. Doesn't have to be witnessed, doesn't have to be dated, doesn't have to state the amount of consideration. Consideration means money, so it doesn't have to state the purchase price. It doesn't have to be notarized. Everybody knows what notarization is, right? So it doesn't have to be notarized, and it doesn't have to be recorded in order to be valid. Now what did I say the purpose of a deed was? To do what? Transfer title. So that means as a grantor, I can sign a deed, not do it in front of a notary, and hand it to Jeff, and Jeff will have title to that property. Right? That's what we're saying here. Here's the thing though. How do we know as a public who owns a piece of property? Well, records where? At the county court. How do they get them? They have like NSA spying going on. How do they get them? We tell them. We take the record down there and we do what with it? We record it. We pay some money and they make a copy of it and they put it in the public record. The point of that is to give notice to the world of who the new owner is. Right? So do you think it's in the new owner's best interest to do that? Yeah. Yeah. We want to advertise to the world that we are now the owner of this property. So even though we say it's not necessary to record, how are we going to let everybody know if we don't record? So are we going to record? Yeah. And backing up one more step, we said it's not necessary to notarize, but guess what? They won't record if you don't notarize the deed. So in reality, they are going to be notarized and they are going to be recorded. We recognize in North Carolina is what we call a pure race state when it comes to recording documents. And what that means is that the state recognizes the first one recorded. Here's why, as a buyer or grantee, you want to get that thing recorded. Let's say I own a piece of property, farm, and Jessie comes to me and she pays me $150,000 in cash for that farm. Now, I sign a deed that gives her title to the property. Done my job, right? Jessie is so excited about her purchase of the farm that she leaves here and she goes to the Angus barn, to the Wild Turkey Lounge to have a drink. In the meantime, I have an appointment with Ford 30 minutes later. Ford is also interested in my farm. Ford also pays me $150,000 in cash, and I sign another deed, signing the property over to Ford. Now, they both have valid deeds. Ford goes straight from here, downtown, to the county courthouse, pays the money to record the deed. Now, on the deed, does it list the grantor? Yeah. Me, right? They pull up their records. Who do their records show as the owner? Me. So, is it the right grantor? Does he have a properly formatted deed? Are they going to record it for him? Yes. 15 minutes after he leaves, Jessie finally makes it down there, a little bit tipsy after a few drinks, and she pays to record her deed. Now, they're going to pull up the ownership record. Does hers identify a grantor? It identifies me as the grantor, right? They're going to pull it up. Who do they show as the owner of record? Him. Are they going to record her deed? No. Who just lost $150 grand? Jessie. Even though she paid first, she got her deed first, what did she not do? Record first. So, it is imperative to get that deed recorded first. So here's your first lesson about closing a transaction. Don't ever give the seller any money until what's happened? Until the deed's been recorded. Now, in reality, it's not going to be you as a real estate broker holding the money until the deed's recorded. Who's going to perform that function in North Carolina? The closing attorney. That's their job. As much as they want to make themselves seem fancy and important, all they do is guard the money. That's what they do. Their paralegal does all the damn work. They don't do anything. Their job is to guard the money. We say, so who do you think that the attorney is representing in the transaction? Whose interest are they representing, the buyer or the seller? The buyer, because it's the buyer who stands to lose, right? So here's the way a closing works. And I know I'm getting off the rails a little bit, but I think it's good to understand it before we get there, right? If we brought up the topic, we may as well talk about it. The way a closing is going to work is you're going to sit down in an office somewhere, maybe at your office as a real estate firm, maybe at the attorney's office, and a bunch of documents are going to get signed, and people are probably going to give a check to the attorney. But the attorney's not going to give checks to real estate firms. He's not going to give a check to the seller. The attorney's going to hold all that money. And then they're going to go down to the county courthouse, and they're going to record all the documents. And once all the documents are recorded, then and only then will they release the money to the seller and the real estate firms and the inspectors and everybody. Because here's what's going to happen. If they get down there and they can't record the deed, has the buyer lost anything? No, because the money's still sitting in the attorney's trust account, right? That's why we use that protection for the buyer. Think about those documents they're going to record when they go down there. What's the first thing the buyer wants to have happen before title gets transferred into their name? What do most sellers have that a buyer wouldn't want to get transferred over with the property? Liens, right? There's going to be a property tax lien, right? What other kind of lien might there be? A mechanic's lien, maybe. What else? A big one. Mortgages. So who do you think is going to pay off the mortgage? Are we going to cut the check to the seller and trust them to send the money into the bank? Who's going to pay the mortgage off? The attorney. They're going to cut a check to the lender. So when they go down to the courthouse, the first thing they're going to file is a document satisfying that mortgage lien. So when the attorney walks into the courthouse, essentially what you've got is in the public record, Dusty owns this property with a mortgage lien on it, right? First thing the attorney's going to file is a satisfaction of that lien. So now who owns the property? Dusty owned it with a mortgage loan on it first, right? So now, who owns it? Still. Dusty, but he owns it what? Free and clear. What's the next document that's going to get recorded? The deed. Now we're going to transfer title from Dusty over to Megan. Right? So now who owns the property? Megan. How does she own it? Free and clear. Now she probably had to get a mortgage in order to purchase it, so what do you think the next document he's going to have to record is? A new mortgage, placing another lien back on the property. That's the progression that you go through in recording those documents. Does that make sense to everybody? Okay, good. Yep.
On that example that you used where you sold the deed to two people, but somebody got to the courthouse first.
Yep.
You said that they weren't recorded unless it's notarized. But just for me to know, the notary has to notarize it right there on the spot, right?
Correct.
When you give the...
Yeah, that's the whole idea of notarizing is you notarize as they sign. Right. Yes.
Also, because you was drinking, doesn't that make that waterproof?
Well, who was drinking? You mean Leslie?
You.
I was never drinking. When was
Yeah,
I drinking?
Who was the seller?
I was never drinking.
Jesse went to drink.
Jesse went to drink to celebrate after the fact.
Oh, okay.
Yeah, I was not drinking. I'd like to be, but I wasn't. We can fix that if you want to, you know. All right. So is everybody good on? Yes.
Is this still happening physically? I mean, can it
Go in to record documents?
Yes.
It depends on the county. Some counties allow for electronic recording of documents now, and some do not. Wade County does allow electronic recording of documents. Durham and Orange counties do not.
So there's a limit to how many they can process per day, right? I mean, they're open from like 8 to.
Yeah, but it's pretty quick.
Oh,
It's pretty quick. I mean, because it's basically as fast as they can scan them, they process them at $26 a page. Nice. And if you go outside the margins, they charge you $25 to move the scanner margins too. And they do have an ATM conveniently available. Charge you a $300 fee to use it, but it's there. All right. Types of deeds. There are really three main types of deeds that you may see on the test. Okay. The first three on here are the ones that you need to be very familiar with. Very, very familiar with these three types of deeds on a test. I'm going to say the most important thing about them now before I start talking about the differences between them. I'm going to point out the similarity, and it's the only thing that really matters. What is the function of a deed? Any deed? Transfer title. So which one of these do you think works best at transferring title?
General.
None of them. They all do it exactly the same. They all transfer title exactly the same. There is no difference between them in that regard. That's why I like to point that out at the beginning, because that's the similarity. We're going to talk about a bunch of differences between them, but the big similarity is they all transfer title exactly the same. So the question is, why do we have different ones? Well, like most things in the law, it's rooted in stuff that really doesn't matter anymore. If you go back 200-300 years, the only way you can guarantee you got good title to a piece of property was to take the seller's word for it. I mean, how are you, what are you going to drive your horse and buggy over to a courthouse that maybe didn't exist and try to find records for, it wasn't feasible, right? If you go back far enough, this research was impossible to do. So at some point you had to take on good faith that the person selling you this piece of property actually owned it, number one, and that they had the legal right to sell it to you. So different deeds were created that had different guarantees. Sort of like going to buy a car right now. If you buy a brand new car, you expect it to have what kind of a warranty? Bumper to bumper, right? We'll back it up no matter what it is. If I buy a brand new car, man, if I drive off the lot and something don't work, I expect them to fix it. Like right now, right? That's the general warranty deed. That's the bumper-to-bumper warranty. Now, who's giving the warranty? The seller, right? The seller is saying, I guarantee you that you have good title. And I'm so convinced you've got good title, I'll back it up. You don't have to worry about anything. You still got title, whether it's good, bad, or indifferent, you got it, right? This is just a backup title. Well, in this middle one here, the seller's saying, I think you got good title. I can guarantee you I didn't do anything shady with it, but the people before me, I don't really know much about them. So this is like you go buy a used car and it's got like a 30-day warranty on it, right? You got some guarantee, but it ain't great. And then you got the buy here, pay here lot. You drive it off the lot, it's yours, right? If it blows up as soon as you get in the street, it's gone. That's a quitclaim deed. That's where the seller is saying, look, man, I don't even know if I own the damn thing. But if I do, it's yours. But you see, it doesn't matter which one of these you use. They all transfer title. If I have title and I sign a deed, it's transferred. Does that make sense? The question is, am I also guaranteeing that transfer? Okay. So the general warranty deed has 4 guarantees, 4 warranties. Who's making these again? What's another word for seller on a deed? What's the deed word for seller? The grantor. The grantor is making 4 guarantees with a general warranty deed. Number 1, I own it and I have the right to sell it. Kind of an important guarantee. I own it and I have the right to sell it. I guarantee you that. Number 2, I guarantee you there are no encumbrances that aren't listed on the deed itself. In other words, there's no restrictions on your use of this property that I haven't told you about. I 100% guarantee you there's nothing you don't know about this property. Remember that whole chapter about encumbrances? So things like easements, covenants, and if you happen to have like a fee simple defeasible deed or a life estate going on, all those would be encumbrances, right? Limitations. So we're guaranteeing here, the grantor is guaranteeing that there are no, not that there are no encumbrances, because there's always encumbrances, right? There's always some kind of restrictions against property. We're guaranteeing you that there are none we haven't told you about. Does everybody follow that? The third guarantee is the covenant of quiet enjoyment. I mentioned this when we were talking about the bundle of legal rights. Remember I said it has nothing to do with having a good time and being quiet about it? It means that you are guaranteed, the grantor is guaranteeing to the grantee, that if somebody else comes along, so Dusty is selling this property to Ford, and he's giving Ford a general warranty deed. A month after the property's transferred, so now Ford owns it, right? He's got the property, living in the house, farming the farm. A month later, Carlos shows up at the front door of this house and says, I don't know who you think you are, but this house belongs to me. He makes a claim against that property. Whose problem is that claim? Is it Ford's problem? Or is it the person who's making the guarantee's problem? The person making the guarantee. So what Dusty's essentially saying here as the grantor is that if some yahoo shows up and tries to claim that you don't have good property, or good title, excuse me, then I will come back and defend your title. You won't have to go to court. I'll do it. I'll take care of it. I'm so confident that I am giving you good title that I guarantee you won't have any problems. Does that make sense? That's the guarantee there. And then the last guarantee that a general warranty deed gives is I promise all of this stuff is true all the way back to the beginning of the time and all the way forward into the future. This warranty never expires. So how many guarantees do you have with a general warranty deed? 4. It's pretty much unlimited, right?
So what about the assurance?
Sorry?
Assurance.
What about assurance?
Is that?
But there's a permanent.
I know, just those 4. Just those 4. Now, the special warranty deed. How many bullet points you see on this slide?
2.
So how many guarantees you think there are? 2. Sounds like it's half as good, right? Really not even there. Not even close. Because not only are there only 2 of them, but they're kind of limited. They're kind of flimsy. I'm going to back up so we can compare here. The first guarantee in the general warranty deed is I guarantee you that I own it. 100% guarantee I own it and I have the right to sell it to you. The first guarantee of a special warranty deed is I have a deed with my name on it. Whether I actually have title or not, it's anybody's guess. But I got a document that says I have good title. That's all I'll guarantee. I got paper that says I own it. You see how that's a little bit wishy-washy, right? It's actually a lot wishy-washy. So that's the only guarantee that the seller's making on that front. The grantor is saying, I guarantee I have a document, a deed, that shows I have title. And then the second guarantee is, I guarantee you that I have not placed any encumbrances on this property while I've owned it. Now, does that say anything about encumbrances before the grantor owned it? I'm going to tell you when this deed is used most often. So you can put it in your notes. This is a foreclosure deed. That's a foreclosure deed. This is the deed that a bank would use to convey title to the person buying it at the foreclosure sale. Not the deed that's going to transfer title to the bank themselves. You got two transfers going on. When we foreclose on the property, we first take it, there's a deed for that. That's a special deed, a special use deed. It's called a trustee's deed. You don't need to know that, okay? But when the bank sells it to Jeanette, when she buys that foreclosure listing and Bank of America sells it to her, they're not going to give her a general warranty deed. Because here's the thing, who's making those guarantees? The grantor is, right? So it would be Bank of America making those guarantees. Bank of America would be guaranteeing that I guarantee there are no encumbrances on this property that we're not telling you about. They don't know what the original borrower did. For all they know, the borrower could have borrowed 5 more mortgages against that property, right? So they're not willing to make that kind of a guarantee. So what they'll say is, I guarantee you we haven't placed any encumbrances against it. Does that make sense? So this deed is going to be used most often in a foreclosure sale.
How's Jeanette gonna clean that up?
And that's a great question. That's the natural question. His question is, how does she clean it up? In other words, does she have to give everybody that buys it from her a special warranty deed? And the answer is no. She can choose to make whatever guarantee she wants. She can turn around and sell it the next day and give the next person a general warranty deed. Because all she's doing is making guarantees. That's it.
Would she want to use a special warranty deed or a general warranty?
That's a question for her attorney. It's a question for her attorney. But there's no restriction on her turning around and using the general warranty deed for the next transfer. Because it's whatever guarantees the grantor feels comfortable making. Everybody follow that? Okay? And then the last one, the quitclaim deed. How many guarantees you think we got here? None. It's also called a non-warranty deed. It literally says, if I own it, you can have it. In a lot of legal terms. That's what it says. Why?
That seems useless.
Well, it still transfers ownership. If I own it, you got it. It works. You're just not getting any guarantee that you got anything with it. So here's where we use it. And it's used a lot. Sometimes paperwork gets lost. Sometimes you got 5 sisters who own a piece of property because their parents died, and only 4 of them signed the deed to sell the thing in 1942. Now, how many of them should have signed the deed? All 5. There's 5 of them, all 5 should have signed. And you go back and you look at the deed and only 4 of them signed. Well, that sister that didn't sign is dead, but she had 12 children. And they each have 3 children apiece now. So how many potential claims are there on that 1/5 of that property? Too many, right? And, oh, by the way, those 12 children are all married, so those spouses have a marital interest. You've got 100 people all of a sudden who might have some tiny ownership claim about this property. Does everybody follow how that could happen, right? Because all they're going to do is show up and say, look, my great-grandma owned part of this farm. She was one of the 5. It was left to her in her name, right there in the will. Here's the deed. She never signed it, so give me my money. I own part of this thing. I'm moving in next week. We call that a cloud on the title, or a defect in the title. It means that somewhere the paperwork didn't get done correctly, right? So, usually this comes up when you're trying to sell the thing, right? You go try to sell it to somebody, they hire an attorney, their attorney does a title search, they go back and they research and they say, oh hell, here's a problem. Right? Their attorney, the buyer's attorney, brings it to their client, the buyer, and says, you got a problem buying this thing because here's this break in the title 50, 60 years ago. I wouldn't be comfortable buying it if I was you unless that gets fixed. And so the buyer tells the seller, look, I want to buy the property, but you got a problem with the title, and until you fix that, I'm not interested. So the seller says, I'll fix it. You know how to fix it? They go find these people who might have claims on this property, and they say to them, it's not going to be them, it's going to be their attorney saying it to them, they're going to say to them very bluntly, listen, you may or may not have some tiny, minuscule claim against this property in Robinson County, North Carolina. You can spend $100,000 in legal fees trying to prove you've got a $5,000 claim in this property. Or, we cut you a check for $500 right now and you can sign this quitclaim deed. What you gonna do? Most people will take $500, $1,000, $100, whatever it is, and they sign the quitclaim deed. Now the quitclaim deed, if they don't have a claim against the property, have we heard anything? No, because the quitclaim deed says, I don't know if I own it, but if I do, I transfer it over. And that's what we use them for. Yes, ma'am.
Can public notices be used with that as well?
How do you mean?
Meaning if you can't find these people and they post, you know.
Yes, eventually you can extinguish the claim if you can't find them. Yeah, eventually. Okay? Also use these in divorces when there's a judgment ordered for, one spouse to give their half of the property to the other spouse. Use quitclaim deeds for that purpose as well. It's a way to remove somebody from the title. Okay? Everybody good on that? Which one's better at transferring title?
All of them.
All of them. All do the same thing. All do the same thing. There are bunches of special purpose deeds and they all do exactly what their names sound like. So when you look at special purpose deeds, if the thing's going to be a gift, which one of these do you think you use? Deed of gift. If you're gonna sign a deed instead of being foreclosed on, which one do you think you use? Deed in lieu of foreclosure. That phrase "in lieu of" means instead of, right? So here's what would be happening there. I'm behind on my mortgage. My bank is about to foreclose on me. I go to the bank and I say, listen, I will save you the trouble. You don't need to pay an attorney. You don't need to file a suit. You don't need to do any of the paperwork. I print up a deed and I will sign over. Because what does a foreclosure accomplish? The bank does what? Take the property to sell it to get the money, right? So I'm walking into the bank saying, I'll save you the trouble. I'll sign it over right now to you. That's a deed in lieu of foreclosure. Leave me alone, I will sign it over to you. We've already talked about excise taxes. Alright, that's going to be it. It's a good stopping point for tonight. We will come back with involuntary alienation on Monday.